buying a property for the purpose of repairing, remodeling, or repositioning it to be put back on the market in a short period of time to be resold for the purpose of making a profit is commonly referred to as flipping. It's not as easy as it may seem. Some people are really good at it and others are not. There are people making a living at flipping and plenty who have failed. You have to buy right, have the vision of what needs to be done to make the property more appealing. Most of all, you have to have a solid plan and be able to execute it in a timely manner. There's clearly risk involved. Now, there's a new law in California that will make it a little harder for some property flippers. However, it will bring more transparency and peace of mind to the buyers of these newly renovated homes. I'll explain. This new law is officially called AB-968, but many know it as the Flipper Disclosure Law. Starting July 1st, 2024, any seller entering a contract to sell a single-family residential property they have owned for less than 18 months must do the following. 1. Disclose any room additions, structural modifications, alterations, or repairs made to the property since title to the property was transferred to the seller. 2. Provide the buyer with copies of any permits obtained, or at least make them available. 3. Provide the names and contact information of all contractors performing any work, including labor and materials, over the dollar amount named in Section 7027.2 of the Business and Professions Code, which at the time the law is going into effect is $500. Disclosing modifications and providing permits is pretty much business as usual for home sellers. Where this gets interesting is the requirement to provide contact information for all the contractors who made modifications in excess of the Section 7027.2 amount. This alone could have meaningful implications. To begin with, some flippers can be very protective of their vendor network and consider these contacts as more or less a trade secret. They built their team through years of trial and error, which naturally will make some flippers reluctant to share their contacts. However, requiring the seller to provide the contractor's contact information for work performed in excess of Section 7027.2, which is the dollar amount requiring a contractor's license, gives the expectation that the work be performed by licensed contractors. Home flippers are in the business of turning homes around quickly and economically so they can make a profit. There's a lot of people flipping homes using unlicensed contractors and independent laborers who they pay directly. Having the requirement for the sellers to name and provide contact information will bring extra scrutiny to who worked on the home and if they were qualified to do so. Some sellers may try to flip homes using the owner-builder exemption to get around the contractor license requirements. This exemption has very specific requirements, like being your principal residence for over 12 months prior to the completion of the work. You should consult an attorney if this is your plan. If you are an unlicensed contractor doing work on properties for the purpose of resale, you should be aware that this new disclosure could get you called into question. Even if you have a contractor's license, you should know that you might be contacted by the new homeowners regarding the work you've performed. AB-968 also applies to people who don't see themselves as home flippers, but for whatever reason sell a property 18 months or less after they take title. If this could be you, you want to be extra careful who you hire to do home repairs. Let's not forget that as of the time this law goes into effect, this amount is just $500. Even when this amount is eventually increased, it will still be low. This extra level of transparency ultimately protects the buyer and is a good thing. Remember, there is a reason that this law was passed. Anyone who's been in real estate a while has seen the downside of poorly done renovations by flippers, where corners were cut, resulting in a lipstick on a pig at best and downright fraud at worst. Bottom line, there's a new law called AB-968. It affects single-family homes, including condos, and goes into effect July 1, 2024. It requires any seller who has owned a home less than 18 months to disclose all additions, modifications, alterations, and repairs made to the property. The seller also needs to provide or make available all permits obtained. They must name and give contact information for all contractors doing over $500 work on the property. And this number includes labor and materials. This new law puts additional burden of disclosure on sellers specializing on renovating and flipping properties. It will put extra scrutiny on the changes made and the people doing them. However, it will bring some much needed transparency and peace of mind for buyers of these properties. Who knows? It may cause some less qualified property flippers to get out of the market, leaving more properties for those good ones. Hope you found this useful and informative. Please like, share, and subscribe, and we will do our best to keep you informed. If you're looking for a real estate broker or a property manager in Long Beach, Los Angeles, or Orange County, California, or if you're just considering it and have a few questions about real estate, contact the Mike Dunphy Group today. We're happy to help.